Good morning, good afternoon, good evening, everyone. I'm very pleased to welcome you all to this new webinar on privacy rules related to the news of the transatlantic data privacy framework many have spoken about recently as a possibly, as we will learn from our speakers, new way of settling the transfer of data from Europe to the US and vice versa. It's been very debated in the last years, as we know, and actually as we will learn also from our speakers. And we will want to learn from them more, especially for the sake of companies that have to transfer data as part of their operations. Together with us today, and I'm very pleased to welcome them, are Magdalena Kogut-Czarkowska from the law firm Timelex in Belgium. Hello. And Hugo Nagashima from the law firm Frost Brown Todd in the US, evidently from the hearts of both countries, because Hugo is speaking to us from DC. I will not take much of the time of the audience, so I would invite both of them to briefly introduce themselves, and then I will have a bit of questions concerning these interesting topics. So Magdalena, if you want.
Hello, everyone. Thank you very much for the invite to this webinar. And my name is Magdalena Kogut-Czarkowska. I'm an attorney at Timelex, which is, as you mentioned, a niche firm that is based in the heart of Europe in Brussels. And we specialize in IP and privacy laws. We work for international clients, but we also work for the European Commission, and we look into the future of laws, not only the laws that are already out there.
And Hugo.
Hi, thank you for inviting me. My name is Hugo Nagashima. I'm a member at the law firm Frost Brown Todd, a 500-person law firm. We're a full-service firm, so we specialize in more corporate litigation matters. I specifically work on matters concerning data servicing, which is data privacy, data security, tech transactions, and intellectual property work.
Excellent. So not only because of their quality, but definitely we invite everyone in the audience to contact respective firms, and Magdalena and Hugo to receive advice on privacy matters and TMT practice in the broader sense. Definitely, they are the exclusive members of privacy rules for the respective jurisdictions, and certainly them and their colleagues are at the best of the practice in respective countries. So let's start with a little bit of historical background. Hugo, I would ask you, certainly our audience have heard about the safe harbor first and the privacy shield. Which was the context of these two different agreements?
So just in the big picture, safe harbor was the very first agreement, that the transatlantic agreement, or a framework that existed before the GDPR, during the EU data protection directives days. And then you have the privacy shield, which came more towards when the GDPR was coming into existence. So let's just start with the history of the safe harbor. The safe harbor was became effective back in 1998. So that's way before the GDPR, when EU came out with its data protection directive. At that time, the directive also had issues of international data transfers. So the US Department of Commerce issued what's called the Safe Harbor Privacy Principles regarding the export of personal data. And this basically included, I believe, seven major principles. 6 of them was mainly what the companies had to abide by, and then an enforcement mechanism. And just to give you some idea of what it is, it basically required notice, which organization must notice the purpose of the collection and use of personal data, and that individuals would have the right to complain, the right to basically inquire and lodge a complaint to the organization. Choice. An organization must offer an individual with the opportunity to opt out from sharing personal data. We see that these days in privacy policies. So that's one of the ideas. Onward Transfer. So this is when a company transfers information to a third party. acting as a processor or agent, as we would say in the US, or a service provider. It may do so if there's a understanding of adequacy, as we understand the same protection of the country reported, and also there's consent from the data subject. Security is very important. We see that principle throughout, which is organizations must create create a security policy, which would have, maintaining, using, or disseminating personal information and taking reasonable precautions without losing their information, without having it misused or having unauthorized access. Data integrity, similar concept. Personal information must be relevant for the purposes which it will be used, and if there's further processing for a different purpose, you must get permission to do so, so consent to do so. Access. The individuals whose data is being collected must have access to their personal information, so that they could view it, they could correct it, they can then ask to be deleted. So basic principles we see today. Then there must be an enforcement mechanism in which there's a recourse for the individual and a remedy, essentially, if there's an investigation or a dispute. So those are the 7 principles that was required under the safe harbor rule. And then, of course, this worked until Schrems I, which I believe Magda will talk about it in her part. Then the US EU Privacy Shield comes later. And this also is a product of the EU-US transatlantic data transfer issues. And again, this was designed by the US Department of Commerce, the European Commission, and the Swiss administration to provide companies to comply with EU data protection requirements for international data transfers under the GDPR. This came into force in 2016, and the framework is a little more complicated because there's Schrems I that happens, I believe, in between. But let me just go over the framework at a very high level. First, you have, so instead of just focusing on what the companies had to do with safe harbor, this required governments to take on certain responsibility. There's basically 3 big pillars, which I'll just walk through really quickly. The first one is providing EU individuals rights and legal remedies. So EU individuals can file a complaint to a Privacy Shield participant, and this would be enforced by the European DPA, together cooperating with the FTC, who has jurisdiction over the participant of the EU-US Privacy Shield. There's also a component of oversight and cooperation by EU DPAs. So the Department of Commerce would commit to supervise this Privacy Shield. When Privacy Shield is a framework in which, as I will talk later, companies participate in it. They self-certify that they will abide by these rules. But of course, companies could say it and not really follow it. So the Department of Commerce stepped up and said, hey, we will supervise it and make sure people are abiding by it. They're actually not just saying it, but their systems in place are verified, and there's no false claims that they're participating, but not really. Those will be investigated by the Department of Commerce. There's also a cooperation between EU DPAs for finding out whether the American side is, so the Department of Commerce or the participants are actually following the Privacy Shield framework. So if the complaint is referred in Europe to a DPA, the DPA will work with the Department of Commerce. Also, the increase in FTC's cooperation and information sharing with the EU DPA is part of it. So then comes the requirement for US organizations to self-certify and to follow the principles, similar to the safe harbor principles, to participate in the US-EU Privacy Shield framework, which again has noticed, having a privacy policy and allowing EU individuals to have the right to lodge a complaint, data integrity and purpose limitation. We talked about it before. Ensuring accountability for data transfer to third parties, making sure that the processors will also comply with the notice and choice rules mentioned in the safe harbor, and the companies that collect the data would have to enter into a contract with processors and or service product providers, as we call in the US, that they will only process the information for the limited purpose, and ascertain a same level of protection, the adequacy protection. Companies also have to agree that they will cooperate with the Department of Commerce. They won't just say, hey, we're certifying, but completely ignore the authorities and not provide information. Transparency related to enforcement. If there's an enforcement action, they have to write a report, and they would make that report publicly available. And ensuring commitments to follow the Privacy Shield rules as long as they're part of it. And even if they decide to leave the certification process, if they are still collecting information from Europe, they will be protected.
Thank you. Thank you very much, Hugo. Never easy to try to summarize two international agreements in a few minutes. We perfectly sympathize with you, as we are going to sympathize with Magdalena, to try to explain to us the Court of Justice of the European Union that was already mentioned by Hugo, then intervene in this framework. So there are two international agreements, or better to say one replacing another, that regulates exchange of data. And then boom, you have a court of from Europe that somehow does something. So can you explain to us what was the decision of the Court of Justice of the European Union and which were the consequences about it? And if I may, immediately also a related question. Do we have, now that we are talking about the new transatlantic data privacy framework, do we have to expect the court continue monitoring the new framework and whatever will come next?
Okay. So talking from the European perspective about the Privacy Shield agreement, the consequence of this agreement was that the European Commission issued so-called adequacy decision. So when the European companies were transferring personal data to companies that were registered under Privacy Shield, these transfers were considered adequate and legitimate under GDPR. And this all changed in 2020 with the decision of the Court of Justice that you just mentioned. It was a decision in the so-called Schrems II case. I will not get into Schrems I case, but indeed there was one that struck down the safe harbor. But this specific decision, the Schrems II case, was a case in which privacy advocate Max Schrems was challenging the flows of data that Facebook was sending from its Irish subsidiary to the headquarters in the US. And Schrems complained about those flows to the Irish Data Protection Authority, and this case was referred to the Court of Justice. So the Court of Justice needed to look whether these particular transfers, whether the US system offers adequate safeguards. So the concern here, as for the previous case in Schrems I case, was that the US authorities have some access to the personal data of the Europeans once this data is in the US. So in essence, Schrems was challenging the Privacy Shield agreement, whether this agreement should have been put in place and recognized in Europe in the first place. So what happened was that the Court of Justice looked into the decision about adequacy that was issued by the European Commission further to the Privacy Shield Agreement and struck down that decision. So these data flows that we've mentioned, the data flows between the European companies and the US companies that were up to that date based on their certification in the scheme were no longer sufficient. So in a very plain language, they were no longer legal. So all these companies that needed to transfer data from Europe to the US needed to look into other measures that are available under GDPR to transfer data. But the Court of Justice also looked into those measures, and specifically it looked into a measure that is called standard contractual clauses, and whether it is allowed to conclude this agreement that is called standard contractual clauses. So it's a very formal agreement in a way that is prescribed by the Commission, and whether a transfer that is based on this agreement from Europe to the US is still legitimate. So to understand this in a little bit more detail, up to that point, I would say that the standard contractual clauses were a very, very common mechanism. And there were these multi-party agreements. The companies that had subsidiaries all over the world would enter into standard contractual clauses, and they wouldn't worry too much about how the legal system of the receiving country looks like, because the standard contractual clauses were broadly accepted as valid on their own. But what Court of Justice said in the Schrems II judgment was that, well, standard contractual clauses is a contract between two parties, between the exporter in the European Union and the recipient in the foreign country, the third country, as we would say from the European perspective. So it does not bind the authorities of that third country. It is not binding on the government authorities that would wish to access the personal data. So the Court of Justice said you need to examine whether the legal system of the destination country, so in the case of Schrems II, US, offers similar guarantees as the European system. And it found a number of arguments why the US system does not offer such guarantees. And one of them is lack of proportionality with respect to intervention of the security agencies, and also lack of remedies that would be available to EU data subjects, so in EU individuals, to challenge the decisions of the surveillance authorities in the US. So while the standard contractual clauses remained a mechanism that can be used, in practice, it is much more burdensome, especially if you are transferring data to the US, because as I said, the Court of Justice said, well, this is not the kind of standard of protection that we are looking for in a third country. So with all of that, the Court of Justice said, well, if you find out that this destination country is not providing adequate measures, you need to put in place some additional security measures, additional safeguards, as they said, but they did not spell out what are those safeguards, which made it very, very challenging for everyone at that point to know what exactly are the expectations of the court, of the data protection authorities, and what can be done to ensure compliance. So with that, there was immediate talk of what can we do to make sure that this adequacy decision for the US is restored. Is there any way to come up with a new privacy shield agreement, a better one that will get us to the point where these data flows are allowed and there's no more legal risks for the European companies?
It's extremely complicated, of course, and you know, on the one side, this is the reason why there is privacy rules. I mean, it's an alliance of experts that actually can try to shed light in this intricate work, which is not, of course, just limited to the exchange of data between the EU and the US, but it refers to the entire world. I mean, in other episodes of our webinars, we have already mentioned that also the application, the extraterritorial application of privacy regulations is not a unique element of GDPR any longer, but it's coming to the fore actually in Japan this month. It did already in China. So unfortunately, to some extent, the GDPR has set a standard that is becoming applicable internationally. It is important actually to be in the condition to speak to people who have to take decisions in companies. You know, the show must go on, so business must continue one way or another. So now we have arrived to this new framework. Hugo, can you explain to European companies which is the approach of the US legislator, actually the US government? How should European companies read the way that this framework will be interpreted and applied in the US? And it's an initial stage, but still, what can you tell us about this?
Right. So we have the announcement by President Biden, the president of the US and president of the European Commission. And it is very simple, right? There isn't much detail to it. But what we do know is, as Magda talked about, the Schrems II decision, the two governments are trying to address 3 points, which is strengthen privacy and civil liberty safeguards governing U.S. signals intelligence. That's the security agencies, right? Intelligence agencies. Establish a new redress mechanism with independent and binding authority. This is for the EU individuals, further recourse mechanisms. Enhance existing rigorous layered oversight over the intelligence activities. So it's actually, there's an intelligence component and there's a redress component of it. That's, to the extent, that's all what is really said in the announcement that the two parties made. One thing that we should keep track of, however, is the proportionality principle, which was discussed, I believe, in the Schrems II decision. So when intelligence is occurring, we know that there's going to be national security objectives weighed with the protection of individual liberties, especially with the foreign nationals, from American perspective, foreign nationals being Europeans. So we will see some rebalancing there, because we know that the European Court of Justice did not agree that there was enough in a privacy shield, even though I believe I mentioned the privacy shield had certain redress recourse mechanisms. So we'll see how that is worked out. The EU individuals will have further, I think, forums to basically seek redress from the data intelligence collection, and the US government will have to adjudicate those claims. And at the same time, the Europeans will be involved, the European Commission, and maybe further DPA. Cooperation is something that the Americans are imagining, the American government is imagining, but it is still not very clear. And at this point, I think all we can say is that there will be an executive order by President Biden, which will address these issues. But again, that's an executive branch issue. However, certain issues that was raised in the Schrems II decision, like the FISA law, the Foreign Intelligence Surveillance Act, that issue is a law issue. It's going to be addressed by Congress. And we're not clear how Congress will move yet. But at least in terms of what the Americans are looking, is that they're going to rebalance the proportionality of intelligence agencies looking into people's data, and there will be further redress mechanisms for European individuals.
So there is a lot to do still, but again, companies are in need of some clarity. So if you can give, Magdalena, your interpretation. So in your opinion, what should American companies see in the announcement done by the European Commission? So if they can try to start looking at the future, what would your suggestion or your interpretation of the announcement, at least? Thank you.
Well, first of all, I would echo what Hugo is saying. That the announcement that we have is an announcement of political will and possibly a roadmap to implement this transatlantic privacy framework. It's not a legal act just yet, and there have been statements also from the data protection authorities in Europe saying, well, this is not ready yet. You need to comply with Schrems II. You need to keep complying with Schrems II. But I think what we in Europe want to hear is that the willingness to change the policy and the laws of the US to put in place those proportionality measures that Hugo mentioned, so that there are some safeguards to balance the requirements of security agencies and what they need to do to fill out their tasks, and the privacy of people. And the second very important element is some kind of mechanism to allow the people from EU to challenge the government, the US government, in their decisions on surveillance, which is very tricky. We all know this is a very tricky mechanism to establish. And well, what we have to say also is that, well, where there is political will, and there is probably likely to be some kind of agreement between the European Commission and the US authorities, this final transatlantic framework is something that will need to stand in court. So we already know that the privacy advocacy groups like Schrems, the organization that Max Schrems had started, None of Your Business, they will be challenging this framework. So if those concerns that the Court of Justice had about the US legislation as is in place at the moment, if those are not changed, then we would expect that this new privacy framework, or this transatlantic privacy framework, would also be challenged in court and could be struck down again. So we have to understand that these are completely different bodies. The European Commission is a way of, I would say, some form of a government, and Court of Justice is a court. It's an independent court. It interprets the law. So the Commission cannot tell the court what to do, and cannot say, well, you need to keep this agreement in place for political reasons. So in essence, I think we have to be cautiously optimistic, and we have to watch the developments, and the companies have to watch the developments, but it doesn't mean that they should stop and not do anything. I think there are multiple steps that need to be done right now to comply with the existing rules, and with the fact that this transatlantic agreement, it will take not weeks but months to negotiate, to then possibly change the laws of the US, and then go through the process of issuing an adequacy decision in the European Union. That will take months. These decisions need to be consulted, for example, with the European Data Protection Board. So it's a process that needs to be followed, and we've seen it, for example, when UK was exiting EU, and there was also some question whether the flows of data between the EU and UK will continue. And even in that case, it took some time to put in place an adequacy decision for the UK. So I think in summary, keep calm and comply.
Excellent. So we enter in the last part of our webinar. So given the complexity of everything you explained so far, and given the fact that companies need to continue operating on the other side, Hugo, if I can ask you possibly 3 concrete tips that you would offer to companies in this current in the current scenario, in this complexity, what would you advise them to do You know, there is a framework, but it's more a political announcement, as you both agree. So how they can continue operate and transfer data?
Well, I'm going to echo Magda, and as we know, it's going to take a while just to really see what the framework is for companies to understand the detail, and then to go through an adequacy decision and to potentially even be challenged by Mr. Schrems and Schrems III. So the first advice is because there is no framework, if there needs to be a transatlantic data flow now, you keep on doing what you're doing, which is having standard contractual clauses, making sure you have a TIA, transfer impact assessment, and you comply that way, because regardless of whether there'll be Schrems III or adequacy decision, you will still be in compliance. Another thing that companies should consider on the US side is Privacy Shield. Obviously, Privacy Shield will be the basis for this new transatlantic data flows. Some things will change, but the principles will not change. As we saw the history, Safe Harbor, Privacy Shield, you're following the principles. If you plan to be part of the new transatlantic data flow framework, it may be a good time, if you're considering it, to study it, to be prepared to comply with it, so that you can be part of the network. And that may lead you to be compliant, adequate, or Schrems III might come and take you off. But it's something that companies can consider. And the most important is for now, don't worry too much about what has been announced, but it's just keep on studying the developments in the framework, and company executives, along with privacy advocates and professionals, should really be watching what is happening, so that they can then make their next move, so that they can make the move efficiently. May it be stay with contractual clauses or adopt the framework. So studying and being abreast of the latest news is most important.
Hugo, excellent. We perfectly understand that it's not easy to navigate this complexity, but I, in my humble opinion, you're totally right to continue studying and trying to comply with what exists right now, because as you rightly said, Privacy Shield is based on the safe harbor, so we wouldn't expect something to detour completely from what the two areas managed to negotiate so far. I don't think that actually they will start all over everything again, because otherwise, instead of months, as Magdalena was saying, there will be years, and probably the quantic computers will be already there, and the exchange of data will be something that will have to be completely reinvented because of new technology. Now, Magdalena, what would you advise from the European perspective, your concrete tips to companies? What should they do?
So when I talk to companies about compliance and the data flows, I really encourage to look what is going on at the moment, and whether these flows, and to sort of map those flows to understand them and to decide whether they are necessary or not. And to give you a simple example, one of the typical data flows that we are seeing are groups of companies that need to transfer employee data from the subsidiaries all over the world to the US headquarters. And up to a certain point, there was this sort of standard on the market that we would prepare standard contractual clauses that covered all possible flows of any data that can be foreseen for employees. And now we are really seeing a focus on minimalization of data flows, and sort of rethinking whether you need the whole set of data from the European companies to be available to the US. Maybe it's enough to just transfer information about financial results. Maybe it's enough to know the headcount or the hierarchy structure, but not exactly where the employee, where the individual employees live, to give a very concrete example. And we must also remember that from the European perspective, when we talk about transfer of data, we are also talking about access to data from the US, for example, if the data is actually physically still in the EU. So the data doesn't move, but there's someone peeking at this data from a foreign country. So whether it's really necessary for all these people in the organization to have access to such sensitive data. And also when we are looking at the fines and the sanctions that we are seeing in the European Union, we are not seeing many sanctions for the illegal or non-compliant flows of data. I would say the biggest sanctions that are there are sanctions for non-compliance with general GDPR rules. So lack of proportionality in processing data, lack of transparency towards data subjects, lack of minimalization of data and accountability. So those are the violations that really trigger the big guns of the DPAs. So I think while we of course have to think about whether the flows of data that the company needs to do are compliant, there's a much bigger picture, and perhaps the violation that will trigger the fine is not really about the particular mechanism that is used for transferring of data, but about something that even triggered this transfer from the beginning. So I think my advice would be to treat compliance as an ongoing exercise and always challenge yourself whether really the company is doing the best it can to comply with the GDPR, not only for data flows, but in general.
Magdalena, thank you very much. You mentioned the sanctions and fines. One of the constant struggles of us at Privacy Rules is to try to let the business world understand that privacy and cybersecurity are not expenditures. They are really investments. They are investments for the safety of your operations, for complying with the rules and avoiding sanctions, even to avoid reputational damage that sometimes companies receive, and this can kill the business of the company even more than a data breach per se, or the gravity of the sanction. The loss of trust from customers, from clients, from partners, because privacy and cybersecurity have been completely neglected. So even just looking at this complexity from this angle, really the value of the existence of the company, we strongly advise to go always to privacy experts and to cybersecurity experts. You out there listening at us, you can decide to come to the privacy rules experts. Of course, I'm going to anyone else, but look at compliance really as an investment in your current operations and in the future, the stability of the groundwork of your business. Also, because I believe Hugo and Magdalena, you will agree with me that when sometimes privacy is not designed or considered by default, to use some GDPR terminology, there is no time any longer to fix the holes. If you don't comply as early as possible, sometimes you lose control of your data. You don't know where they are, and perhaps you have operated with these data for years and years and years, and then you realize that you didn't have consensus. You didn't really look at the respect of the privacy rights and liberties fundamentally, as our speakers told to us. So it's really an investment in the future of anyone. So I want to thank very much the two of you for already giving some concrete guidance to everyone listening at us out there, what to look for. And I believe that I can already announce that as soon as there will be some more clarity, as soon as we will have some more pieces to the puzzle of the exchange of data in between the two areas, you both will hopefully continue shedding light to our audiences and explain us which additional steps have been taken in order to help the business communities, associations, and institutions of any kind. So Magdalena and Hugo, thank you very much again for being with Privacy Rules, not only today, but also for your activity in the Alliance.
Thank you. It was a pleasure.
Thank you so much.